Hi friends from around the world. You wanted always to know a bit more about the evidence. I hope you want to know, because evidence is an important issue in European instances, court or administrative instances like EU IPO. So you need to know a bit more about that. And today it is about acquired distinctiveness. You know what about the absolute grounds of refusal, right? So the big ones, the normal ones, the 90% ones, so to say, which are raised at the moment of filing are non-distinctiveness and descriptiveness, that you know. And you know as well, Article 7.3 of the European Union Trademark Regulation says that certain absolute grounds, and among those, the ones referring to non-distinctiveness and descriptiveness, these absolute grounds can be overcome by submitting evidence of acquired distinctiveness. Now, acquired distinctiveness, the territory for which you need to prove this evidence is depending on the assessment of absolute grounds. So if it is non-descriptive, or if it is descriptive in 5 European Union countries, because it has a language which is understood there as descriptive, as being descriptive, then you need to file for these 5 countries the evidence for acquired distinctiveness. If it is 6, so 6. If it is 8, so 8. And if it is something which we will see in a moment, if it is a non-word sign, not really meaning anything, but it is too simple to be distinctive, then it would be necessary to file evidence for the whole territory of the European Union, so 27 countries. And that is a very tough issue, I may say. So you want to avoid these kind of simple marks, because you enter into a territory where you will end up with a big headache. Now, what is the case? Let's come to the case I want to discuss here. That is from 2019 and involves the German company Adidas, well known for the sports clothing and the shoes, sports shoes, etc., the sneakers. Now, this is the case here on the screen from the General Court. It went all up to the General Court from the EU IPO. And in 2013, it was filed by Adidas at EU IPO, this mark on the screen, for class headings in class 25. It was considered to be okay, although during the examination process there was a third party which filed observations. This is possible. So if the third party knows there's through publication or whatever, they know that there is a trademark pending for examination purposes, it is possible to submit to the examiner third party observations. And this was being done by saying, well, this is clearly non-distinctive, but although that, nevertheless, this has been registered. Now, it has been registered as a trademark, a figurative mark for class headings in class 25 of the Nice Agreement, right? Okay. Now, in 2014, December, that third party that filed the observations, they made an invalidity request against Adidas for the ground of non-distinctiveness. And it said, well, that is just 3 stripes, so 3 stripes is not something which the consumer would consider to be a trademark, an indication of origin. They would say, no, that is 3 stripes, some ornamental figures on something, and that's it. Now, the cancellation division was accepted, so to say, the initial ground that it is non-distinctive. So, and rejected, well, the first step was to reject the trademark as being non-distinctive. So they had to contradict their own statement a bit before, or the statement of the examiner before. Okay, now it comes to acquired distinctiveness. It was non-distinctive for the whole 27 countries because there has no word element which would be descriptive. So it is equally non-distinctive, as perceived as non-distinctive in all 27 countries. Okay. Now, that would require, in order to persist in their registry, well, they had already signed as an invalidity request now, they had to provide acquired distinctiveness for 27 member states. And guess what? They filed 12,000 pages of evidence. 12,000 pages of evidence. I did not want to be the examiner of that case, neither in the Board of Appeal or in the General Court. Now, 12,000 pages have been filed for all of what they had. Probably they have been filed. Now, the cancellation division, they went all through all the evidence, although they didn't discuss all the evidence in detail in the decision. That would be not possible. So they sorted out they grouped and sorted out certain references, and they came to the conclusion, no, this is not sufficient, at least not sufficient for the 27 member states. And well, they rejected, therefore, the registration of the 3 stripes, which have been called by 3 normal black vertical equidistant lines, right? So that was what it was about. Now it went to the Boards of Appeal, and the Boards of Appeal, they decided along the same lines, and they said, well, much of the evidence refers to somehow similar marks, but they were not identical. So there is the evidence must refer to the contested mark, right? They cannot contest to some different mark, and Adidas had a lot of marks, not to some different mark. So it must concretely this mark. Now there is a bit, so to say, we have some flexibility with regard to that evidence of use if the company want to make insignificant changes, so not changing the character of the mark, but just make some insignificant changes, then it would also count as proof of use for that mark, but it must be insignificant, right? So what happened, they rejected as well, and the changes were too significant so that it could not be referred to this trademark which is under discussion. Well, it went to the General Court, naturally. And the General Court, they assessed what is the case law on the insignificant changes. And here on the screen, you have the extract of evidence which has been put forward by Adidas to the cancellation division and has been examined by the General Court. And you will see that there are differences between the mark applied for, the 3 stripes, and that's it, and all the rest what you have seen on the screen. So what is the differences? Well, the court said the more simple the sign is, and here we have 3 stripes, that is very, very simple. The more the deviances, so the less deviances we have, they may already be significant. So if you have a complex sign, then you change here a bit and change there a bit, but overall impression is the same, then it might be different. You may be a bit laxer with regard to the requirements of significant change. So that is a first issue the General Court discussed here, and which was relevant. Another issue was as well that the registered sign was registered as a figurative mark. Now, in front of the Court of Justice, the Adidas said, well, in reality, it was a pattern mark. With regard to a pattern mark, it needs to have repetitive patterns, which the General Court said, well, sorry, this is not the case here. It cannot be a pattern mark. And figurative mark, there is an implication here. Figurative mark need to have the same proportion with regard to the use. So if you have even the 3 stripes but in different proportions, then it could lead and will lead here, according to the General Court's assessment, it will lead to significant changes. So what about the evidence? I promised you at the beginning. Let us see what are the evidence which may be taken into account for acquired distinctiveness. In any case, in that case here, the General Court, they said, well, even if we take into account a lot of what can not be taken into account, but then we still would came to the situation that we have evidence only for 5 member states, whereas the member states are 27. So if only in part of the, and this must be seen rather country-wise. So 5 member states to 27, no, if it is 26, well, you may have a discussion of what Luxembourg, if Luxembourg is the one which is missing. So you maybe think differently, but 5 out of 27, that is, according to the Court of Justice, not possible. Now, what is the kind of evidence we can or we are looking for? The market share. Market share is an important evidence, but normally you don't have concrete market share to share with the court. So you need to have a market study, but who has market studies of the whole European Union? But there would be evidences, and there would be turnover figures, and there would be, comparison with competitors, or also this would be the one, or statements from, for example, the Chamber of Commerce. There would be a possibility, or then it would be how intensive and geographically widespread and long-standing was the use of the mark. So that would be an important issue. The amount invested in the advertisement. So the ad industry, that would be the promotion, right? The promotion, the amount invested in the promotion from a particular undertaking in order to promote that mark, not any other mark, right? And statements, as I said, from Chamber of Commerce, and so affidavits from Chamber of Commerce, but from the CEO or from the Chief Financial Officer of the company, or from, I don't know, any other. The more independent the evidence is, the better. So if it is an affidavit from an interested party who has an interest here in the outcome of the case, it must be corroborated by other independent evidence in order to be credible. So this is the kind of evidence which you need to have in mind. Now, some last comments on what is the significance of that judgment for you lawyers from around the world. Well, the one thing is, do not overwhelm through mass of evidence the administrative or judicial instances. Mass of evidence is not helpful. It will bring from the beginning a certain, well, negative, so to say, negative attitude from the examiner. But, well, if it is relevant, it is relevant, and you have more relevant evidence, the better. But don't rely on whatever evidence you have without scrutinizing exactly and send it all to the examiner. Leave it up to the examiner to sort out whether which is relevant and which is not relevant. Now, if you have a lot of evidence, then you must structure the evidence according to what would be, evidence with regard to that, evidence with regard to that, evidence with regard to that, to the different things. So the turnover, this is the ad in the advertisement, or this is statements, the nature of use, the extent of use. There may be a lot of structure you can bring into, so that you break down a whole bunch of evidence into smaller pieces, which you can eat much better than the big ones. So if there is a lot of evidence, and hopefully you have a lot of evidence, so more important problem is probably that you don't have the evidence. But if you have the evidence, you need to structure it in a way and to analyze it in a way that you send only the relevant evidence and discard all the irrelevant evidence. Don't outsource this to the examiner. He will slap you on your face. Thank you for tuning in today.